You're watching the legal breakdown. So, Glenn, we are recording this in the immediate aftermath of Trump having been arraigned in a Florida courthouse. Now that Trump's been arraigned, what's the timeline here for what happens next?
We don't quite know yet because no next court date has been set. The reason for that is because a magistrate judge presided over today's arraignment hearing, Magistrate Judge Goodman. Let me tell you, that is entirely usual. The early stages of any federal case, things like detention hearings, preliminary hearings, arraignment hearings, are ordinarily handled by magistrate judges. They're not full judges. And then the case gets passed off promptly to the assigned judge. In this case, it's still Judge Aileen Cannon, which may prove to be problematic. And then Judge Cannon will set the next court hearing and will contact the parties, the prosecution and the defense, and then everybody will be back before her in fairly short order. Now, more broadly, what is the timeline for this case to go to trial? Well, we have to talk about two things. We have to talk about the law, because the law is the Speedy Trial Act. The Speedy Trial Act provides that from the date somebody is arraigned on an indictment, that was today for Trump, until the prosecution must commence the trial is 70 days. Now, mind you, no federal case ever goes to trial in 70 days because there are lots of ways for the parties, both the defense and the prosecutors, to stop the speedy trial clock from running. The defense in particular is usually determined to set a trial date as far out into the future as possible. So 70 days is for starters, but frankly, we could see a trial date in 4 months, 6 months, 8 months, a year. We'll learn more about that in the coming weeks when Judge Cannon holds the first hearing in the case.
Now, obviously, Trump has a vested interest in delaying as much as possible because, he basically wants to be able to hopefully win the Republican nomination, win the presidency, and then basically insulate himself from any charges. So I imagine that he'll just do whatever he can to introduce motion after motion after motion to delay here. So is there anything that the court could do to prevent that kind of abuse from happening?
Absolutely. The court can set strict deadlines for when, for example, motions must be filed. The judge could say, I'm going to give the defense 30 days to file all of its legal motions. I'll give the prosecutors 15 days to respond. We will then set a date a couple of weeks down the road. We will have oral arguments on the motions. I'll make my rulings, and we will move into jury selection in the coming weeks or months. The judge has almost complete discretion, indeed unreviewable discretion. Donald Trump couldn't appeal a motion schedule set by the judge, has, almost complete discretion over moving this case promptly through the system rather than letting a nefarious litigant try to weaponize the delay and run out whatever clock he thinks, it's to his advantage to run out.
Well, that obviously underscores the importance of the role that the judge plays in this case. And, as you mentioned before, that judge is right now set to be Judge Aileen Cannon. We've spoken in the past about how she's kind of interfered in these cases on Trump's behalf. So if the DOJ were to move to get her removed and replaced from this case, when would the time that they would do that be?
They would probably do that as early as, or signal they're going to do it as early as the very first hearing set by Judge Cannon, which I suspect will be in pretty short order in the coming weeks. They can say, Judge, given your history with the case, given that the appellate court unanimously found that you abused your discretion by trying to do something to Donald Trump's advantage that you had no lawful authority to do, we look to the law that sets out the standard for when judges should disqualify themselves. And that is anytime a judge's impartiality can reasonably be questioned, that judge is actually duty-bound to remove themselves, recuse themselves, disqualify themselves. Now, importantly, the law doesn't say, you have to have an actual conflict. You have to be unable to be fair and impartial. It simply says if a judge's impartiality can reasonably be questioned, and Brian, I don't know how anybody could argue that Judge Cannon's impartiality is not subject to sort of reasonable questions once the appellate court unanimously smacked her down, reversed her, and said, in essence, she abused her discretion and ended up interfering in an ongoing executive branch criminal investigation. Those are very strong words. It's a strong condemnation, and I think her impartiality can be questioned if she chooses to continue to preside over this case.
Yeah, although, I would argue that she's likely never going to accuse herself, because if she was coming at this from good faith from the very beginning, she would have never interfered. And so inherently, she doesn't seem like the kind of person who would recuse, because the kind of person who would recuse is someone who has enough integrity to not do what she did in the first place. So, Glenn, does Donald Trump, based on this arraignment, have any conditions or restrictions in terms of what he can do, what he can say, or where he can travel?
No, and that's disappointing. It's more than just a little disappointing to this old career prosecutor, because we have plenty of folks who are sitting in pretrial detention right now because they were deemed a danger to the community. And yet Donald Trump, who I think is as dangerous to the community, to society, and to our democracy as any other person in America these days, there was no discussion at all of any kind of limitations on his travel. There was no discussion on any kind of limitations on his speech or his social media posts where he is, endangering prosecutors and their families, judges and their families, witnesses, jurors. And so I was disappointed that the prosecutors in the case opted not to speak about any of the concerns that Donald Trump may be a flight risk. And I'm less concerned about him being a flight risk because he always has the Secret Service in tow. But I am supremely concerned about him endangering the community and the witnesses and the people's right to a fair trial, given that there are no restrictions placed on him at all. I suggest that if he was any other human being who had violated our nation's espionage laws, obstructed justice, made false statements, been in multiple conspiracies, he would be sitting in pretrial detention right now, pending trial.
Why do you think that was? Why do you think the DOJ, do you think it's just them being overly cautious because they always have a tendency with Donald Trump to treat him with kid gloves?
I think that's part of it. I don't think the whole concept of equal justice under the law is alive and well.
Yeah.
I don't want to detract from just how important a development it is that Jack Smith and his team indicted, and they've now arraigned a criminal former president of the United States. That's huge. But I think if we are to strive for equal justice, when you have guys like Jack Teixeira, you may remember the 21-year-old National Guardsman who was mishandling and compromising classified information. He was promptly arrested, and he has been sitting in pretrial detention since April, pending trial. I would venture a guess that Donald Trump's conduct, his crimes, so far outpaced Jack Teixeira on compromising our national security that it feels like an unequal application of justice to me.
Yeah, that's all completely valid. Glenn, Trump showed up to the arraignment with his co-defendant, Walt Nauta. How unusual is it for one defendant in the case to show up with their co-defendant in the case?
Yeah, they rode up together in the same defendant motorcade, which I thought was unusual. First of all, it looks like maybe Donald Trump is trying to kind of go with and maybe update an old saying that we've all heard, right? Keep your friends close, your enemies closer, and your co-conspirators closest, because they arrived together. He and Nauta, who are co-conspirators charged in the same indictment, they arrived together, for this court hearing. Ordinarily, what happens is when a conspiracy indictment is returned, the attorneys for the various co-conspirators say, listen, it's time to put some distance between yourself and the other co-conspirators. Why? Well, because they might flip on you to try to, earn a deal, a more advantageous position than they're in, or you might have to flip on them. So it's really time to sort of step away from who have been your co-conspirators thus far and let's make some independent tactical decisions about how to proceed in our case. That is not the way Donald Trump and Walt Nauta are playing it. Not surprisingly, Trump always calls the shots. His lawyers don't, which is why he had yet another team of defense attorneys make their first appearance today, which does not bode well for his defense because these attorneys have not been steeped in this investigation for the last year or two. But this is the way Donald Trump chooses to roll. You know, he is always basically a tactical nightmare in the choices he makes.
Yeah, yeah. But it is interesting that he has decided to sink his teeth into Walt Nauta to basically prevent him from, like you said, flipping on him by opting to cooperate with prosecutors, especially considering prosecutors, I don't think at the end of the day are looking to take down Walt Nauta in all of this. I don't think they think that Walt Nauta is the peak of the mountain here in terms of prosecutorial prizes. So obviously Donald Trump knows that, and Walt has opted to let Trump, you know, basically dig his claws into him instead of making the smarter choice, which would probably be to protect himself versus protecting Trump. But
you know, that's exactly right. And I have a feeling the only reason Walt Nauta is named in this indictment is because he refused to cooperate. And then what we as prosecutors have to do, if we want to develop somebody as a cooperating witness, but they refuse to plead guilty and accept responsibility for their crimes and cooperate against their co-conspirators, then we put them in that indictment. That tends to get everybody's attention but quick when they see their name, you know, as a marquee defendant in a conspiracy indictment with a former president of the United States. And interestingly, the only condition that the judge today, Magistrate Goodman, placed on Donald Trump is he said, you can't have any communication directly with Walt Nauta about the facts of this case. You can only communicate through your respective lawyers. However, you can still spend all day, every day with Walt Nauta, your body man, provided you two don't discuss the case. Well, I'd love to know how the judge thinks he's going to police that little arrangement.
yeah, I'm sure that they'll abide by the rules of the court when they're in the privacy of wherever they go. Glenn, we'd spoken about pocket pardons or self pardons in the past. Is this something that Trump would have already used if he'd have gotten one?
Yeah, great question. A lot of people in the last couple of days have been asking, could he have pardoned himself for this? The answer is no, because these crimes, the classified documents crimes, took place after he left the presidency, so he no longer had the pardon power. Now, he certainly could have issued himself a secret or a pocket or a non-public pardon. Mind you, there is no requirement that to be lawful or to, have legal effect, a pardon must be announced publicly or recorded somewhere. The Constitution does not require that. So I have a feeling we're going to see plenty of secret pocket pardons emerge in the future, probably in connection with the January 6th insurrection, because that happened while Donald Trump was president, and he certainly could have tried to give himself a secret pardon for that. So I would say stay tuned on that front.
Okay. And I want to switch gears a little bit here. As if Trump needed another legal issue to worry about, a judge also ruled today that E. Jean Carroll can amend her defamation case, her ongoing defamation case. I guess we would call that E. Jean Carroll 2, because she's already gone to court and Trump was found liable for the first case, but was able to amend that case to include the defamatory comments that Trump made during that CNN town hall. So what kind of an impact do you think that will have on Trump's damages?
I think it's going to be important for two reasons. One, a jury has already found Donald Trump liable, so this may very well result in an even greater recovery of damages, that is money by E. Jean Carroll in the event she wins the second suit. But here's the other really important aspect of this development. Remember, this is the one that originated when Donald Trump made defamatory statements while he was president. And that allowed Bill Barr's Department of Justice to step in, substitute the Department of Justice, take Donald Trump out of the litigation altogether. And basically that went a long way to DOJ being able to dismiss this suit entirely. Then Donald Trump went and defamed her again after he left the presidency, and most recently, as you mentioned, at the CNN town hall. So the other thing this may mean, together with potentially more money for E. Jean Carroll, is that the Department of Justice may reconsider the substitution issue. They've already sent a letter to the judge saying we are reconsidering the substitution issue and we'd like to brief up that topic. So now the temporary win that Donald Trump got in this case previously by Bill Barr swooping in and removing him, that win may now go away, and the Department of Justice may say, listen, given that he continues to defame E. Jean Carroll, we are no longer going to substitute the Department of Justice. We want Trump back in, and we want him to have to defend himself a second time in the suit brought by E. Jean Carroll.
No, if I'm not mistaken, that case is sitting on the judge's docket. So when will we have an answer as to whether they'll accept that case? Because right now the contention is we're not sure whether this can move forward because of that very reason, because Trump can't be held accountable for anything that he did while he was president. So when are we going to have an answer there as far as the judge is concerned?
So the best I can estimate is we're going to have an answer soon, because it's been through some appellate litigation in a couple of different appellate courts. As you say, it has now landed back on Judge Kaplan's desk. Judge Kaplan presided over the first E. Jean Carroll trial, and he is now in the process, I think, of setting a briefing schedule on that precise issue. So we will probably hear more about that in the coming weeks.
Okay. Well, obviously, a lot to keep on top of, especially as this trial, the first federal indictment that Trump is contending with, continues to move forward. So if you're watching right now and you want to keep up with legal news, make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.